you. This is case number 25 CR 153, State of Ohio versus Jonathan M. Knopf, representing the State of Ohio's Assistant Prosecutor Adam King, presenting the defendant's attorney James Chandler. You're Jonathan M. Knopf?
Yes.
All right. Mr. Knopf has entered a plea of guilty to counts 1, 2, and 4. Count 1 being B&E, count 2 being theft, and count 4 being aggravated possession of drugs. They were all fifth-degree felonies. Now, Mr. King, has the victim or victims of counts 1 and 2 been notified of the time, place, purposes, hearing, the right to be heard?
Yes, Your Honor. The representative has been notified and has elected not to attend.
All right. Have each of the attorneys had an opportunity to review a summary?
The State has, Your Honor.
All right. Mr. Chandler, you've had an opportunity to review a summary?
Yes, Your Honor.
All right. Is there anything that the State would like to offer regarding sentencing?
Only was contained in the plea agreement, Your Honor, and there is restitution in this case in the amount of $1,011, and that would be joint and several with the co-defendant. That's all. Thank you.
All right, Mr. Chandler?
Yes, sir.
Mr. Chandler, anything you'd like to say regarding sentencing?
Your Honor, I think he intends to pay his restitution when he receives a bond refund.
I'm sorry, now what regarding restitution?
I said he intends to pay the restitution with the refund on his bond in this case.
Oh, okay. How much was that?
This is $1,100.
$1,011, joint and several with the co-defendant.
All right, and the how much was the bond?
It was $2,500, and then I think he'll get most of that back.
Yeah, I think he gets 90% back.
Yes.
Okay. All right, anything else, Mr. Chandler?
Nothing, Your Honor.
All right, Mr. Knopf, is there anything that you would like to say?
Well, I'll start off. Good afternoon to you, Judge. I've got a problem with drugs. Been a drug addict quite a few years of my life, and trying to get off of them, it's been difficult for me. I mean, I need help, and I got there's a bed waiting for me down at TCC on Monday, and I'm hoping that it'll allow me to keep that appointment and go down there Monday and get some help with my drug addiction.
Anything else?
That's it, Your Honor. Thank you.
All right, well, I'm looking at your history, and you do have previous conviction on several previous drug convictions, 2018 out of this county. One was theft, and the other was an aggravated possession. He got community control, violated, and was sent to prison. Also, unauthorized use of property. And you have in 2022 aggravated possession of drugs, attempted possession of fentanyl, and identity fraud. And it looks like you did 18 months on that, which means you've been out of prison, I suppose, sometime near the end of 24. and now here you are again.
Yes.
I was just looking here at the pre-trial supervision report. You said you need help, and I think here's the problem. I think the problem is you're thinking someone else has to fix you. You have to fix yourself.
Right.
They can, don't talk.
I'm sorry.
They can provide you information, tools, support, but you have to do it. Now, I'm looking here from a reach, a letter that was dated the 17th of February, where you were there on the 11th to update your plan and said you couldn't go because of a doctor's appointment, and then later you contact the program daily, stating unable to attend group sessions, despite ongoing communication, not present for required treatment services, so considered non-compliant. And then I look at the March 19th. We do have there is a bed available for you that was arranged, I believe, through the probation department. And Breach finally did indicate that it was clear you needed to have a stabilization program, an inpatient stabilization program. And then when I look at the probation report, you tested positive almost every time you were tested. Missed your report date on March the 3rd, said to your father's doctor's appointment, rescheduled March the 5th, missed your report, sickness. Reported on the 12th, tested positive. You were told to go to a detox bed on the 13th, and you failed to show for that. So, your claim that you want help, I think, is just so much BS, and I'm not buying it. Now, that being said, due to the contract we have with the state, if I sent somebody to prison for a 5th-degree felony, they have to serve that time locally. And I won't put that burden on the county. But also, I think you need to have your attention drawn to the fact that it's about time you start paying attention to what you're supposed to do, and not because all these things about your dad and your sickness. Let's face it, we know what that is. Those are excuses. You're hiding behind that. You didn't want to come in because you didn't want to test positive, and of course you did. And you have to demonstrate to yourself that you want to be serious about treatment. You're telling me you want treatment, you want help because you think that's what I want to hear. Well, I don't want to hear anything but the truth, and I haven't heard it. So it is the order of the court. I am going to order that you be sentenced to a term of 3 years of community control under these conditions. You're to obey all laws of all jurisdictions, conduct yourself in all body, manner, at all times, report when and as directed, be truthful in all statements you make to probation, keep them informed of your residence, place, employment at all times. You may not change either without prior permission. Not permitted to leave the state of Ohio at any time without prior written permission. You're not permitted to enter upon the grounds of any correctional facility, nor can you communicate or attempt to communicate with anyone who is an inmate into this facility without prior written permission. Because of your convictions for the drug offenses, you're not permitted under either federal or state law to purchase, possess, own, use, or have under your control any firearm, ammunition, or dangerous ordnance. To do so would be a federal and state felony violation for which you can be prosecuted and incarcerated. It's also a condition you not have any of those or any other items of any type while you're on community control. You're not to purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of a controlled substance that has effects similar to those or drugs of abuse, nor may you have any instrument, device, or thing that may be used to administer drugs, prepare them to be administered unless you have a lawful prescription. You have to provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as requested. You're not purchase, possess, use, or have under control any alcoholic beverage or be present at places where those are sold or being consumed, even as otherwise lawful. But associate with any co-defendant in this case or any other person has a criminal record as a member of a gang or any other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense and violate these conditions. unless approved in writing by your supervising officer. That applies to any family members other than those that were residing with immediately before the commission of this offense. After the date of this order, you may not marry or establish cohabitation in a common law marriage type of relationship with another without written permission. Must report any conviction, arrest, citation, or other charge violating the law not later than the next business day after that occurs. Must provide your supervising officer a financial information record so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for an evaluation or assessment for any further treatment, therapy, counseling, or training or other educational programming, you'll submit to that. And if any treatment's indicated, you enroll in and successfully complete that. Be required to pay the court costs of this action. To pay restitution in the amount of $1,101 to, is that?
It's $1,011.
Oh, $11, okay. $1,011 to V1?
Just V.
Just V. All right. And that will be paid in full from the refund of your cash bond. It is joint several with your co-defendant, which means that you will be entitled to collect one half of that $1,011 from him, but that's burdens on you. You don't get to pay your half and then have to chase him for the other half. That the law puts that burden on you. Now, it's also going to be required that you successfully complete the STAR program and any aftercare. While I don't doubt that you have a substance use disorder, you also have a real problem with thinking and trying to take any kind of accountability or learn anything from what you've done. And so that's what one of the things this STAR program is designed to do. And I understand you've been taking online Suboxone, and that's just a legal pill mill. That's another piece of BS. That's all that is. Akron. Who do you know in Akron? Nobody. You went online because all you got to do is get a credit card and tell them, ABC, and here comes your Sublocade or your Suboxone, and that's just another racket that hopefully the law is going to sooner or later get rid of because it's not legit. It's just pill mills, and so you won't be able to be on Suboxone to start, but they can put you on Sublocade, which are pills. And if you don't want to be on Sublocade, they're going to kick you out. And if they kick you out, it's going to be a violation of your conditions because you're going to be required to successfully complete the STAR program and recommended aftercare. So what's going to happen is once you come out, they're going to recommend that you go into treatment, and you're going to do that. And if that recommended you go into residential treatment, then that's what you're going to do. Now, they can't force you. You can tell them, no, I'm not going, because they're not going to force you. But guess who can? Me. And you're going to do it. Yeah. So if they say, this is what we think you should do, you don't have to say, I ain't doing it, unless you want to say, call the sheriff and have him come get me, because I ain't doing it. So, those are your choices. Do it, we're going to, come back here, and then we'll deal with it. And at that time, you're probably going to be looking at serving, even though I don't want to put you in a county jail, that's what you're looking at. Going to the bed's available on April the 1st, I believe. So you'll be taken into custody immediately after the hearing and remain in jail until you're conveyed to STAR. Now, in the event that the probation department feels that you're not complying with these conditions, they'll file a written notice out with the court. You'll get a copy. There will be a hearing. at which you'll be entitled to have counsel. If the outcome of the hearing is that you have failed to comply, then at that time, the court can revoke your community control and sentence you to between 6 months as a minimum and 36 months as a maximum. You could also be fined $7,500. If you end up being sentenced to prison at some point, upon completion of that, it is optional under the law for the Adult Parole Authority to decide whether to put you under post-release control or not. They do. You'll be supervised under the conditions they set for a period of up to 2 years, and if during that period of time they determine that you've not complied, then they can return you to prison and make you serve an additional period of up to 9 months for a single violation, up to half of your prison term for all violations. However, if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year. Whatever time is left on that period of post-release control, whichever is greater, if that occurs, that has to be served consecutively to the sentence in the new case. All right. Is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody.